Welcome to the Ezra Digital 2020 Education Series. I would now like to turn the program over to Steve Bisbee for introductions.
Thank you, Mallory. I'm Steve Bisbee. I'm the president and founder of eOriginal, a leading digital transaction management platform for financial services. At eOriginal, I oversaw the initial development of unique, purpose-built digital solutions that have replaced paper-based transactions and created business process efficiencies for over 600 clients within a digital financial ecosystem. The Electronic Signatures and Records Association was formed to educate and advocate for the use and acceptance of digital signatures, records, and transactions. I've been on the board since its inception. Our members are dedicated to providing, promoting, and participating in the Ezra values of expertise, leadership, collaboration, accessibility, and technology neutrality. As part of Ezra's educational mission, we have created this education series. The education series provides insight and practical guidance on the business, technology, and legal implementation issues across a wide spectrum of applications. These include presentations by Ezra members and their partners on topics ranging from remote online notarization, digital mortgage, and auto finance, to the use of voice signatures and other biometric methods to authenticate signers and execute documents. Although eSign was enacted 20 years ago, there's still a learning curve as companies continue to transform their business practices. These transformation issues are even more critical during this time of social distancing, remote work, and contactless consumer engagement. We hope that you will find these webinars useful. Now, it's my privilege to introduce our speakers today, Margot Tank and Dave Whitaker from DLA Piper. DLA Piper is a global law firm with lawyers located in more than 40 countries throughout the Americas, Europe, and the Middle East, Africa, Asia Pacific, helping position clients with their legal needs around the world. Margot is a partner of DLA Piper and the U.S. co-chair of the firm's financial services practice. Margot is also counsel to Ezra and an ex officio member of the board. Margot and I are the co-chairs of this Ezra's Digital 2020 Education Series. Margot has been assisting companies with digital transformation for over 20 years. She has assisted over 1,000 processes and platforms that enable digital transactions and digital payments, including those in the financial services, commercial, consumer retail, and the healthcare space. She has significant experience in applying the law to the issues raised by new technologies such as electronic signatures, digital asset transfer systems, artificial intelligence, blockchain, smart contracts, virtual currency, and IoT. Her clients range from Fortune 500 to startups. Currently, she and her team are working on over 50 digital transformation projects, including some that span the globe. David is a partner in the Chicago office of DLA Piper and advises traditional and emerging financial services companies and commercial enterprises in transactional, legal, and regulatory matters, particularly those related to electronic commerce and digital financial services. David has extensive experience with the practical application of the laws governing electronic banking, letters of credit, payment systems, records management, and commercial and consumer financing. David also advises clients on laws related to privacy and data security in connection with electronic financial services and electronic payments. He has written extensively on both law and practice related to digital financial services, electronic commerce, and digital transformation. Both Margot and David have been deeply involved in the creation and monitoring of legislative and regulatory initiatives governing digital transactions for over 2 decades. Please welcome Margot and David.
Thank you, Steve. Wow, that was quite the introduction. Thank you. So on the agenda today, we're going to talk about some good news, good progress, some of the ongoing issues that we still see 20 years later, and our favorite topic this year has been remote online notarization. The title of the presentation is Legal Year in Review. It really is 20 years in review as we think about digital transformation and all that's happened since the eSign Act was enacted in June 2000. There's been a lot of progress. Many pain points have been addressed. Consumer demand is at an all-time high, COVID-19, clearly the global pandemic has pushed companies who thought about going online to actually go online out of necessity. Excuse me. Better technology, time passing and expectations changing, the loosening up of worrying about whether an electronic signature or an electronic record is actually valid and enforceable and effective. The regulators in the last few years have been quiet, which has given time for companies to actually invest and continue to change business processes and move them online. Industries are definitely engaged. Judicial precedent exists. You know, when we first started 20 years ago, there was a lot of, well, what are the courts going to say? Well, the courts have been saying a lot. They have been very supportive of the electronic environment. We have a few cautionary cases that we're going to talk about today that David's going to talk about. We have, as an illustration of some of the progress, we're going to point to the MERS e-registry. So for those of you in the mortgage industry, I think the numbers here are incredibly impressive. As of October 31st, there have been 836,775 e-notes registered. But what's more impressive is the numbers in the last few months. So just bear with me while they give you some of these statistics and think about how they might pour it out into auto finance and banking and every other industry. But this at least is something that we can actually measure at the moment. So in October, a record 66,575 e-notes were registered, with a 269% year-over-year increase from starting January 2020 to October 2020. The ratio of e-notes to paper notes has increased from 3% in January 2020 to over 5% in September and 6% in October. So we're clearly, progress is happening. I'm not sure we can say tipping point quite yet, but I think these numbers really illustrate the momentum forward. In addition, we talk a lot about needing to have all the players in the ecosystem kind of aligned, because eSign and the UETA are opt-in laws. So everyone has a choice to go electronic or not. What's also, I think, fascinating is that when you look at the MERS participants, you have originators, warehouse lenders, servicing agents, sub-servicers, investors, and custodians all participating in the process. So everyone's rowing in the right direction or in the same direction. So it's great. With all the progress, okay, there still needs to be mentioned that eSign is still opt-in. We still have eSign consent and reasonable demonstration issues, which we can talk about further as we go along here. We have mobile issues, the small real estate, unclear how that will be addressed on a go-forward basis, as we have a new administration who has been more active in the consumer advocacy space. Courts have been supportive, but they are a little bit schizophrenic, and David's going to talk about that. We still have the bookends of a transaction, meaning the authentication at the outset of the transaction and the record integrity at the back end of the transaction, and data security and privacy concerns. Those things are going to exist and are going to impact the speed at which there's digital adoption. I think the internal and external resistance to moving online is being diminished. However, it's still there. there's still a need for education, and hence we have this education series. So hopefully that's helpful. We still have some interoperability and integration issues to be tackled. Expenses and associated with getting online and updating legacy systems, and certainly in a pandemic when companies are minding their expenses, this might cause a little bit of speed bump. Statutory complexity, and we're going to talk about that in particular. Our example today is remote online notarization and all the complexity there, and lack of uniformity. And I think that's probably enough of the speed bumps for now. But let's talk about some of the ongoing cases that we want to illustrate today.
All right. Well, if Margot, if we had a couple of slides.
Yeah.
We can talk about a couple of those cases. What we're seeing is a few key issues are starting to be the center of kind of judicial attention, particularly moving from late 2019 into 2020. And the cases we're going to talk about here at the moment are actually, for the most part, if you check out the dates you'll see on the slides, hot off the presses. This is all new stuff. And most of it, you'll also notice, is they're not reported decisions. They're not decisions, for the most part, with a couple exceptions, that are turning up in the reporters. But what we're paying very close attention to is what's happening down on the ground, what's happening at district courts, what's happening at Court of Appeals in the states where courts are making decisions about the use of electronic records and signatures, and aren't necessarily deeming those cases now as significant enough to merit being included in, say, for example, the Atlantic or Pacific Reporter, and don't expect them to actually be quoted as precedent per se. But they are very indicative of the judicial thinking that is going on in this subject, and the fact that the courts are still cheerfully happy to discover after about 200 to 300 years that they've got a brand new area of common law to work through, and they're loving it. And they're also doing, for the most part, a pretty darn good job of going through it and making choices. You've probably, if you've been attending these presentations for a few years, either remotely or at the ESRA annual conference, you've heard Margot and I say that any number of times, that they mostly get it right. One of the things that they are focused on now are signature issues associated with attribution of the signature and the intent to sign. You have probably heard us say any number of times that legal sufficiency and attribution are two different things, and the UETA and the Federal e-Sign Act only answer the question, is it a signature? Doesn't answer the question, is it your signature? And the burden of proof is generally on the person seeking to enforce the signature. We've had incidentally, some static on that issue recently, where plaintiffs have turned up, in particular defendants in cases, and saying, well, I say it's so-and-so signature, now the burden's on them to actually prove that it wasn't. But if you pay close attention to those cases, they're kind of what's called a bursting bubble presumption. The party who wants to enforce the signature shows up and says, well, this is John Doak's signature. And then the counterparty, who does not want to see the signature enforced, basically stands up and says, no, it's not either. And that's really all it takes to burst the presumption. Despite what you may hear from time to time in individual court cases about, well, once the signature has been proffered, it's up to the person who is disputing the signature to go forward with the burden of proof. it's really not much of a burden of proof. It's mostly a no, I didn't. Same with intent to sign. The intent to sign is a key element of the definition of electronic signature in both UETA and eSign. And so in circumstances where the courts have questions about whether or not the party who supposedly signed understood they were signing, the intent to sign will turn up as an issue. Two court cases to look at here are Malone versus Hoogland Foods and Reed versus Eastside Medical Center. And in those two cases, we have cases of courts looking very closely at the facts that were actually being considered by the court at the time that the signature was entered into. For example, in the Hoagland case, I'm popping up my cheat sheet here because those cases are complicated enough. I need to cheat a little bit. The court concluded that they could not decide whether or not the plaintiff had intended to sign the document in question. The plaintiff was hired by the defendant, and as part of the employee onboarding process, was sat down in front of a computer in person where an employee password and user ID was created. And then supposedly the employee was supposed to agree to the terms of the employment agreement, which included an arbitration provision. But in this case, the employee said, wait a minute, yes, I sat down in front of the computer, but there was also a human resources representative sitting next to me. And the human resources representative actually did all the typing on the keyboard and never said anything to me about the fact that I was supposedly signing or agreeing to an agreement. And I didn't actually take any action with that keyboard other than typing in the password when I was asked to create one. The keyboard was passed to me. I typed in the password. I passed the keyboard back. That was my only interaction with the keyboard. And the court said, well, in that case, we're not able to establish that you had any intent to sign, that you understood you were signing, and so we're not going to enforce that signature against you, at least not without more of an evidentiary hearing, certainly not on a motion to dismiss, certainly not on a motion for summary judgment. This is a factual dispute. In Reed versus Eastside Medical Center, there was a denial of another motion to compel arbitration because even though the agreement contained a typed electronic signature, there was a question about who had done the typing. It was another in-person interaction. And in that case, the plaintiff, against whom the defendant was trying to enforce the arbitration agreement, said, I don't remember either being presented with this agreement or ever typing my name, and you can't tell anything from that signature because it's just my name typed on a line. And again, the court concluded there was insufficient evidence to tie any action by the signer to the signature that appeared in the document. There was no kind of audit trail, there was no kind of history, no kind of set of recorded actions that suggested that any one person other than another had typed a name into that field. And so even though in order to enter the medical facility, supposedly the plaintiff had to first type in their name on that agreement, the court felt that wasn't enough by itself to establish any kind of attribution. Now, if we can go on to the next slide, there's a point I want to make here about the intersection between the Malone and Hoagland Foods case and Reed versus Eastside Medical Center and the different kinds of authentication that are out there in the world. We have often talked about the fact that there are many different kinds of initial authentication. There's positive authentication, which is examination or certification of documents from a trusted third party. Might be a government issued ID. Logical authentication, linking up information you receive from the signer to information that's available from outside sources. Negative authentication. Well, the information that signers provided us is not tied to known, essentially, auspices or evidences of fraud, like the mail address they gave us is a known mailing center. It's not a known mail drop. You can have knowledge-based authentication. We see a lot of those, of course, out there in the world, the KBA test, where you to have information pulled from a series of credit reports or other information, other databases, and the person who's going to sign first has to prove they are the correct person by demonstrating their knowledge of personal information drawn from those databases. And then, of course, there's self-authentication. I'm me, which might be combined with positive or negative authentication as well. Then there's ongoing authentication with the use of persistent credentials, things like a user ID and password, like was created in the Hoogland case. Now, the interesting thing to note is that in both of the cases we just discussed, Malone and Reed, there was, in fact, some kind of authentication along these lines going on. In the Malone case, there was the creation of a credential. And in the Reed case, there was personal appearance before the party with whom they were supposedly going to sign the agreement. But in neither case were those actions or those strategies for authentication tied to the signature in the way that a court found convincing. And this is also something we may potentially start to see turn up, and we are a little concerned about with respect to the use of email linking as the sole method to establish the identity of a signer, particularly potentially in consumer transactions. The notion that, well, we sent X an email, and that email had a link in it, and you had to click the link in order to start the signing process, right? Is that going to be enough? Some of these court cases that are looking for a tie between the authentication method and the signing event in order to establish intent or attribution are suggesting that there's going to be need to be very careful in the future concerning being able to connect those dots together. Now, if we go on, we'll touch on a couple other subjects that are also turning up down at the courthouse, and that has to do with scrolling versus jumping through agreements and hyperlinks. With respect to scrolling versus jumping, we are seeing courts express some skepticism concerning platform tools that permit citers to jump ahead to each signature line in a presented document without having to in any way review or pass through the document they're signing. Again, particularly probably in consumer transactions, probably less so in commercial transactions where parties are expected more to be able to look out for themselves. For example, in FTC versus Elegant Solutions, the FTC's motion for summary judgment for violations of Section 5 of the FTC Act, which prohibits unfair or deceptive practices, was granted in part because the defendant's online application automatically jumped from signature block to signature block instead of requiring the consumer to scroll through the document, and that this then encouraged the consumer to ignore the disclosures and statements that were made in the documents that they were jumping through in order to get to the signature lines. Then with respect to hyperlinks, we are getting continued confirmation from the courts that hyperlinks work, but they have to be used correctly. For example, in Dorman versus Intuit, a use of a hyperlink as part of a click-wrap agreement process was upheld by the court because the sign-in process that the customer went through made it very clear that the customer was agreeing to not one, but two agreements. And the links to the two agreements were clearly and directly expressed and exposed to the customer at the time they were signing. There was a dissent, however, and dissent objected to the fact that those two agreements, while they were clearly presented by hyperlink, were presented by hyperlinks that appeared below the sign-in call to action rather than above it. And so that's worth noting because on the one hand, a majority of the judges were okay with those two hyperlinks appearing below the call to action, but there was a court participant, a judge, who was concerned about the fact that they didn't appear above that line, illustrating that the hyperlinks do work if they're clearly presented, but it's still important to think about presentation, because if those, it sounds like in this case in particular, if those two terms of use hyperlinks had appeared above the sign-in, there wouldn't even have been a dissent and it wouldn't have been a close call. Now, in Snow versus Eventbrite, the court actually was sufficiently concerned about the way the hyperlink was presented that they refused to enforce it. It was basically one of these situations where the call to action was in very bright and colorful language, and then the terms themselves were expressed through hyperlinks that were presented in dark gray on a gray background. And under those circumstances, the court was concerned that the links were not sufficiently conspicuous, were not sufficiently clear, was not prepared to enforce those links, to enforce the agreement based on the way that link was provided. And finally, in Arnault versus Doctors Association, the court was not willing to enforce an arbitration agreement because the presentation screen was extremely cluttered and there was no conspicuous size or font used to present the link to the terms and conditions. And furthermore, the button that the customer checked as kind of a call to action just said, "I'm in," probably confirming to us that being hip probably isn't quite as good as being certain that the consumer who is agreeing to terms understands that they are agreeing and sees words like "I agree" as part of the call to action, as opposed to simply "Yahoo, let's go." So those are all things to bear in mind about the proper way to use a hyperlink and the kind of thought process we're seeing down at the courthouse from judges as they look at deciding whether or not to enforce.
And what's interesting is when you look through 20 years of cases, the initial, right, maybe 1999, 2000, up until 2005, roughly, the courts were, supportive of browse wrap and click wrap, and they thought anybody who's actually online is a sophisticated user of the internet, and they were fairly generous unless the facts were completely obviously bad and unfair. What we're seeing now, and really in the last probably 7 years, the courts are really digging into the particular facts. They're looking at screenshots. As David mentioned, they're looking at size and font and color and button labeling. They're looking at the net impression of the entire transaction, even if it's technically correct and you got a e-sign consent at the right time in the transaction and you presented the disclosures and the disclosures had all the right terms in them, how the entire process is presented to the, again, consumer transactions is going to matter. If, for example, every action that the consumer has to take is a yes, and the last action is a question that says, do you want to, opt into paying a fee? For example, the courts are saying, oh, you set it up so that the consumer was checking yes, 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 yes. You kind of led them to that last yes. So the net impression, the presentation of the entire process really is going to matter. We mentioned this case a few years back, but it's worth mentioning again, Berkson versus GoGo. It really is a very, very good illustration of how the judge went in and looked at exactly what the hyperlink was labeled and exactly what the buttons were, and talks about the reasonable internet user and even gets into brain function and the likelihood of where customers will typically look first and second. So as we go forward into the next decade, there's going to be a lot of focus on how this is done. The more we move online, which is all the progress, the more transactions, there will be more scrutiny to how they're being done.
And I think for those of you, particularly in the financial services industry, do not lose sight of the fact that courtesy of the United States Supreme Court, it is very likely that the new administration coming in on in January is very likely to immediately install a new director at the Consumer Financial Protection Bureau. And you can likely expect, you know, here's me prognosticating about politics, folks. You can likely reinvigorate CFPB after January of this year. That will probably be thinking a whole lot, to Margot's point, about net impression.
Okay, so remote and electronic notarization. We'll talk about some of the differences, but here's a slide that provides the states and the citations for remote online notarization statutes. South Dakota is a RIN state, RIN meaning remote ink notarization, not a true RON, remote online notarization, where everything is signed electronically, but it's on the list here. I would expect that this list increases, again, COVID pandemic. Emergency orders are also in place now that we're sort of headed into second wave of COVID again. Either emergency orders will be extended or statutes will be enacted. The state of Michigan had its executive orders overturned by the court. So my guess is that other states will not want that to happen, and they'll move forward with legislation.
There's an example of that is if I can bust in for just a second. Example of that is New Jersey. New Jersey started out with a COVID order. The New Jersey legislature actually enacted a temporary RON law. The law, though, only extends as long as the governor keeps issuing 30-day extensions of the state of emergency for COVID-19. And as soon as the governor doesn't sign another 30-day extension, he signed the last one on October 25th, doesn't sign the next one, doesn't sign one on a January 1st, vaccine becomes available, woohoo! You know, March 1st, he starts signing the extensions. Unless New Jersey changes that statute, it goes away. So it's statutory law in New Jersey, but we don't know how long it lasts for, and we don't know when it's going to end.
So just a little bit more background on RON. As I mentioned, you have remote online notarization where the entire process is audio, video, and electronic. Notary signing electronically, and the signer is signing electronically. Remote ink notarization is audio, video, but documents are printed out, can be ink signed, can be scanned, and then emailed back, or can go FedEx or some other route to then the notary, who then may also ink sign and complete the process. In-person electronic notarization, which is referred to as iPen, that has been in place for 20 years. The UETA and eSign both have enabled notaries to sign electronically since the beginning of those laws' creation. So UEDA was 1999 and eSign was 2000. What was contemplated was that the notary would be in person, in the room, but the transaction would be done electronically. URPERA, the Uniform Real Property Electronic Recording Act, also supports, again, in-person electronic notarization and recording. So we have this sort of evolution over time. RULONA, which is another uniform law on notarial acts, has gone through a number of revisions over the last 20 years and is now fully enabled, again, for RON transactions and RIN transactions. There are about, I believe, 10 states that have enacted RULONA in some form or fashion. I'm going to go through just some of the kind of commonality, and then we'll get into some of the notable differences and some of the issues that are cropping up in terms of implementation that are becoming complex and are being treated in an ununiform way. So here's the commonalities are: the signer may appear before the notary by means of audio-video communication. Okay, great. Notary must be present in the state of commissioning when performing the notarization. This is the same as paper. Must use a tamper-evident process. So alterations of documents must be able to be detectable. Doesn't matter where the signer is located. Proof of identity of the signer. All states have some form of credential analysis. Notary's personal knowledge, credible witness, or reliance on some form of two-factor authentication. There's a need to keep a copy of a recording of the session, typically 5 years. Some states have 10 years. And there is a need for a journal. So at a high level, seems fairly doable, but there are definitely notable differences among the states. So the authentication requirements differ. I'm going to go to the next slide. The authentication requirements differ. The tamper seal requirements differ in that some states are focused on record integrity, in that so long as the document is tamper sealed, that's sufficient, where other states are focused on the notary actually having their own digital certificate. The journal and recording requirements differ. Sometimes the recording needs to be in the journal. Sometimes it's required that it's not in the journal. Some states require compliance with ADA rules. Some states do not. Some states have an approval process. Some states do not. There are various custodian requirements or requirements for RON platform providers, which are different than what the notary requirements are. Some states enable paper printouts to have the notary say that it's a true and accurate copy. So in those jurisdictions that don't permit recording, the paper is sufficient. That's not all the way across the board. I think there will be an effort underway to have some of the non-uniformity smoothed out, but that's going to take some time. User adoption it's it's happening, but there's going to be an emphasis on privacy issues. State privacy laws are already starting to be enacted. For example, in Colorado, the RON regulations say that the information that is obtained, the non-public personal information that's obtained as part of the transaction, cannot be used for any other purpose. It can't be sold, it can't be used for marketing, but we're going to continue to see that type of privacy law sort of impact potentially the use of these platforms, or just require additional disclosure. Same with biometric laws. There may be just general connectivity issues. As we all know, we've been trying to live remote for 9 months now, roughly, and some days it works perfectly and other days it doesn't. User sophistication will clearly be an impact on the transaction. Drop signer issues. How long can a signer be gone in the event that there is a connectivity problem? Does the signer need to come back on within a certain time frame? The laws are silent on that specific question. Do they need to be re-credentialed? The answer is yes in some states. Other states are silent on that issue. Do you need to strip signatures in the event that a signer has signed but the notarial act has not taken place yet? Or if there are multiple places in a particular document that need to be signed, when do you need to start over? Because some of the laws say that the entire process, transaction, notarial interaction needs to be recorded and must not be interrupted. So what does all that mean in the event that there is a problem? As I mentioned, ADA compliance, we've been talking about ADA compliance for years. Because we are now mostly remote and will be probably for the foreseeable part of 2021, ADA is just going to continue to be an important issue to pay attention to. Allocation of responsibility among the notary, the platform, the document provider, the signers, and so on is also something that's going to need to be thought through terms and conditions and other contractual arrangements. So there's a lot going on with RON and RON compliance to be aware of. So in the interest of time, let's, if okay with you, David, let's open it up to questions. And I believe that you can type your questions into the chat box. And Steve, I'll turn it to you to talk about public policy while people are typing their questions in.
Thank you, Margot. Once again, thank you for sharing such valuable information and content. So I want to talk just a couple of moments about ESRA and the public policy initiatives. This is a sample of some of the things that we have been focusing on. We have separate committees for, and as Margot and David just talking about, e-notary is a very big issue. We have a lot of participation in that particular area. We have folks that are members that are dedicated to the electronic will legislation. And we've been working on the IRS and forms now for probably 15 years, certainly for a long period of time. We have DDI and a bunch of other folks that are focused on the vehicle titling agencies and how do we actually digitize the DMVs. Very, certainly a challenge. One of the things that we have been successful with in assisting is the digital odometer statement. The Federal Home Loan Banks is now something that has been coming forward. And now with the Federal Reserve Banks, where a lot of the programs for subsidized loans during this crisis, now these loans need to be able to be taken and purchased by the Fed, and how they're going to be done in the digital environment. So these are all that are very active public policy initiatives, and there's certainly, if anyone has any interest in other topics or areas that they'd like to see Ezra work on, we invite you to join us for that purpose. Mallory?
Great. We do have a couple of questions that came in. Well, one's a comment, one's a question. So the first question is, since wet signatures on paper don't typically have attribution of the authentication, so like a notification that DL viewed, etc., to the paper signed, why are the courts holding electronic signatures to a higher standard?
You know, that we've talked about that for 20 years, okay?
Right.
But here's the hardcore reality. Most courts have actually never experienced testimony from a handwriting expert. And I'm using that wording, that phrase in quotes, okay? I have actually been involved with real live evaluations of signatures by handwriting experts as part of my prior life as a banking lawyer. There is a completely unrealistic view down at the courthouse of what you get out of a handwriting analysis. And so you find a lot of courts and judges that still have kind of this expectation that if a document has been signed manually, that it is going to be easier to determine whether or not that signature is genuine. My experience is that is not the case. And as a matter of fact, if anything, in many instances, it's way easier to establish attribution if you have a proper electronic process for establishing attribution than it is to establish attribution of a disputed signature when it's manually executed. But that has not been the attitude. And we see that expressed occasionally by judges in court decisions where they grouse, even though they'll enforce the electronic signature, they'll grouse about the fact that it's not a manual signature. Margot, I don't know what else you would.
Yeah, no, I think the question is spot on. The emphasis is absolutely more on the digital transaction than in a paper transaction, but I think the answer is only because we've had, how many years since we went from stone carvings to paper, and all the court cases, and a comfort, essentially a comfort level. I mean, it's not really a great answer. Not only the courts, but just even the agencies. We just went through the CARES Act, Small Business Administration, PPP loan process, where if you, they all had to be submitted electronically to the SBA, but if they were signed electronically, the requirements were NIST requirements, which are very stiff with respect to attribution. And to David's example earlier, where if you sent an email to someone with a hyperlink in it, that would have been insufficient. There needed to be some sort of in-process authentication or attribution of the signer to the actual signature. So you could send an email with a hyperlink, but you would then maybe send a one-time password to an out-of-band process. So you couldn't use email, you'd have to use a cell phone, for example. So I don't think this issue is going away. Attribution and attributing the signer to the signature is here to stay. Net impression is here to stay. Record integrity and tamper seals are here to stay. For many years after eSign was passed, the definition of an electronic signature is so broad, any sound, symbol, or process, people said, well, do we have to use a digital certificate? And we have always said, no, you don't, because of that definition. But what is happening is that those sort of three components, which is, identity, attribution, and record integrity, all are wrapped up into what a digital certificate is. That maybe that's the direction that we're headed in. Although,
it's going to be interesting the next couple of years, because this all ties into, some of you will probably remember, there's been a long-standing kind of debate in the United States about federated identity, federal identity, and the question of indisputable or non-repudiable identification and authentication. And we continue to occasionally see calls for that to address exactly what Margot is talking about. Is it like, well, we need to be absolutely sure. And this is incidentally kind of an echo of the European attitude, or at least the attitude in parts of Europe and in parts of, very much in South America, okay? We have to be absolutely sure that we know who is doing the electronic signing. And under those circumstances, the debate, I think, is going to go on. But I will also say to you, frankly, that if you think back over the last few months and the public dialogue, if I can call it that, over masks in the current middle of the COVID-19 crisis, you can guess just how likely it is that we're going to get some kind of extensive identification process or federal identification process in the United States in the near future. The psyche just doesn't seem to be there to do that sort of thing. So attribution and schemes and strategies for attribution are going to continue to be very important, I think, for at least the midterm, because we're not going to see any kind of universal solution to that problem. I would say that anybody who comes up with a universal solution that's also universally accepted by users will be the next Thomas Edison.
Mallory, any further questions?
All right, that is all. No further questions at this time.
All right, one last thing I wanted to mention. But sorry, Steve, I was going to say one last thing I wanted to mention, that because this is the legal update and year in review, we do publish on a monthly basis a publication called eSignature and ePayments News and Trends, and it has laws, regulations, and cases that relate to eSignatures. We are going to compile all of that every month and put it into one link, and we will be providing that for a resource for Ezra members and for those who attended today. Back to you, Steve.
Well, thank you very much, Margot. So we only have a couple of moments. I just want to let you know that we have a lot more great content coming up as we take the digital education series throughout the end of the year. We have Doc Magic, who's presenting on December 3rd with a focus on e-mortgage technology, and DDI and Ann Gunning presenting on December 10th on the digital transformation in the automotive world, both selling and lending. And then on December 16th, we have First American DocuTech, which is also going to be talking about mortgage closings and how they're functioning in the age of COVID and utilizing the RON capabilities that Margot was talking about today. So you can find out more about Ezra and this series on Ezra's website at www.esignrecords.org. We hope that you would join Ezra and gain the benefit of the combined expertise of our members, including David and Margot, but also support our advocating for a trusted digital economy for all. So please look at the membership section of our website. On behalf of Ezra and our speakers, we thank you very much for joining us today.